The debate in academia that our concepts, according to academic freedoms versus intellectual properties, are managed by concepts that apply to the classroom and the institution. The United States Supreme Court in Clark versus Home declared that we do not conceive academic freedom to be a license for uncontrolled expression at variance with established curricular contents or internally destructive of the proper functioning of the institution. The courts further held that certain legitimate interests of the state may limit a teacher's right to say what he or she pleases. For example, the need to maintain discipline or harmony among co-workers. Number two, the need for confidentiality. Number three, the need to curtail conduct which impedes the teacher's proper and competent performance of his daily duties. And number four, the need to encourage a close and personal relationship between the employer and his superiors, where that relationship calls for loyalty and confidence. Therefore, the Supreme Court declares that free speech of faculty members must be governed by the environment in which this free speech is to be held. To make a broader claim without inciting a riot, perhaps, you want to have a structure, a balance, and an ethical responsibility in free speech for faculty members, as thus saith Clark versus Holmes in a Supreme Court decision, 1972, Seventh Circuit Court. Distant education makes this difficult. So while our Supreme Court guides the tenure and the institution-based learning processes that impact academic freedom and perhaps intellectual property rights or laws, these ideas apply differently to courses and instructional material to be offered at distance learning. The temptation is to make academic freedom coterminous with the security of professors in the Guild. The Professional Teachers Guild organizes and manages ways for increased efficacy, access, quality, and reduced cost in learning. These faculty unions are being challenged by the adjunct professor who would accept teaching for immediate monetary resolve but are not connected to the tenure policies and procedures of academics that institutions must manage themselves based on. What this means is the adjunct professor is not part of the research and development team that creates new identities in educational design, etc., for the enhancement of learning opportunities, not only for the institution, but for all citizens. While adjuncts may be part of the conversation, they are not on paper in the final analysis. Because adjunct professors are not included in the final analysis, there are certain limits to their instruction and their prerogatives in teaching. For example, they have not been through the strenuous criteria of competency and competency ratings to manage their structure in a classroom as a tenured professor. This is why it can be argued that academic freedom is increasingly being threatened by a stifling culture of conformity in higher education, and they are restricting academics. Cost effectiveness at institutions are reasons why adjunct professors are hired, because to give someone benefits and access to steering the course of learning practices through the social dynamics of the Americas as we know it in education, whether it be race related or status related, the freedom of academic thought and the progress of knowledge are being challenged. You know, the foundations in which academia and universities are built have changed truths. The critiques of existing knowledge and the pursuit of new truths. The fondness of the rhetoric and academic freedoms are increasingly criticized. For example, the African American who had established institutions on their own for a lack of access into broader academic institutions have a different cultural philosophy to the foundation of the American educational system. This can be argued. The politics and the intellectual trends such as feminism, the critical theories, identity politics, some of these concepts were not made available for the masses. So now that the masses have full access to education, thus saith Brown versus Board of Education, Little Rock 9, and the different civil rights procedures of the 1960s, 1964, academic freedom and the prerogatives of teaching and learning are in a debate with a cultural conformity. And this debate creates passion in a place that should be managed by facts, in my opinion. Without getting too political, the concepts that apply to research and its product, when they can be streamlined from demographics or cultural assets, the research and development relationships increase. Sometimes they're managed by collaboration agreements, non-disclosure agreements, joint development agreements, sometimes mismanagement of a trade secret, know-how, intellectual asset management, licensing, encumbrances, propriety, information, and intellectual asset training may not be a legal method that is carried out effectively. There are instances where what must be shared, what may be shared, and what must never be shared can impact research, product, and the application of protecting institutional property in regard to furthering a study. While with the influx of distance learning and international studies being prevalent through online coursework, excuse me, this is an early analysis, an early study. However, the research and development relationship are a design that must be part of this conversation. Because research and design must be part of this conversation, we beg the question, what rights do institutions have regarding products? What right do institutions have in regard to developing products using institutional funding? An academic essentially has and wants an audience, and this may be disproportionately made up of teachers and students, while an intellectual has and wants teachers and students in his audience only in proportion to their place in the general educated public. The academic being the specialist and the intellectual being the generalist. And this is, again, depending on the subject of how it impacts differently. We begin the dialogue with the common good, the free search for truth and open discussion versus personal interest and institutional interest. And personal interests and institutional interests are not education. They are big business. So that conflict of interest of what is what needs to be very, very, very clear so that these concepts of academic freedom and ethical responsibility and academic responsibility are being interpreted in what intellectual property is, or product property, and how the individual or the institution, etc., may be managing their intellectual product as a personal or institutional property, and then whether or not that's part of the common good for humanity. And because the conflict of interest of personal interest, institutional interest, and whether or not it's common good must be explained in specifics, we beg the question, what rights do institutions have to control the work of faculty serving as experts while being employed by the university? Well, if through function of the university a level of expertise and tenure was attained, and or a level of tenure was attained without functioning as an expert in a field outside of a university, and then that tenure was brought to a place, this criteria must be recognized. Public education must manage academic freedoms based on the history of the professor, the ethical responsibility, and academic responsibility, while a private-based institution can put within their contractual agreement what actually occurs in the relationship between teacher and institution, and answer the question a lot clearer of the rights that institutions have to control the work of faculty serving as experts while employed by the university. Again, this is managed by an external context. This external context includes society, industry, in regard to industry protecting their economic investment, and whether or not this connects freedom of teaching and research to draw people into the study and discussion through the institution, commanding society to engage in ideas for the common good. Science, Research, and Discovery, 1934. We talking laws here. Academic Freedom and Tenure, 1925. And the Statement of Freedom and Tenure of 1940 helps us govern these concepts. The defense of autonomy of scholarly enterprise versus protecting intellectual property. Again, we cannot mistake understanding why something is supported versus understanding what something actually is. I am Diallo Robinson, student, North Central University. Thank you very much. The concept of academic freedom as it applies to institutions in regard to intellectual protection has a history that is ethically responsible and academically responsible. For the private-based institution, academic freedom and intellectual protections are managed on contractual agreements between teachers and the particular institution. However, in public education, there's a much more narrower conjunction into the identity of free speech and academic freedom. While free speech is for the citizens of a country, academic freedom is in tune and in line with the freedom of speech, however, only for furthering the interest of study and research of the academic institution. Academic freedoms essentially are situated and protected by tenure for teachers, and that tenure offers more brevity into the idea of free speech. What this means essentially is that professors who have earned their tenure and managed a discipline within their particular field of study are regarded in the information that they share and given more room to determine issues that may conflict in academia. While academic freedoms and intellectual protections cannot be mistaken for understanding why something is supported versus understanding what something actually is, the defense of autonomy in scholarly enterprise versus protecting intellectual property in fields of economics, public policy analysis, philosophical theory, and literary criticism must be managed at a point where university resource and interest, are managed by or conflicted with university conflict or interest. In layman's terms, this means the common good or free search for truth and open discussions versus personal interests and institutional interests govern academic freedoms. The freedom of teaching and research to draw people into a study through institution and society creates an external context in which finance from industry who protects investments and society participate in this external context. Depending on the subject, it impacts differently. However, the legalities that are consistent with academic freedom create a vehicle for debate in academia.